Here. Here.
Here.
Here. Here.
If everyone would please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, let's start with the preliminary announcements. The First District Court of Appeals graciously lets us use their facilities, so please respect the rules and have absolutely no food or beverage other than water in this room, and please silence your cell phones. We've received feedback from the public that sometimes it's difficult to hear members and those before the commission, both in the room and over the live stream. So anyone addressing the commission, please make sure to speak up, speak into the long microphone at the podium, so you can be heard, and our broadcast and audio recording equipment can pick up your comments. My fellow commission members, please speak up and into the long microphones so your comments and debate can be heard. If you share a microphone with another member, pull it as close to you as possible when speaking. Members, I ask you be as brief and concise as possible in your questions and comments, as we have a number of items for consideration today. I'm already breaking the rule by not speaking into the microphone, as usual. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. All righty. On to item number 3, which is consideration of the June 6th, 2025 public session minutes. Is there a motion to approve those minutes?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye. And then next is the set of minutes from the July 7th public video conference meeting. Is there a motion to approve those minutes?
Second.
All in favor?
Aye.
All right, both motions pass. Before we get into substantive matters, I want to welcome our new commissioners, Rogers and Phillipson. This is our first in-person meeting together, so it's wonderful to have you all. Thank you for being here.
Madam Chair.
Thank you.
Number 5 on the agenda is a joint stipulation, consideration of the joint stipulation in complaint number 22-082, and Ray Venice Gilmore has been continued to the second September meeting. So we're going to move right into item number 6, which is consideration of advisory opinions. So the first one that we'll consider is file 2817. So any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the commission who need to make a disclosure regarding file 2817? Right, and is the requester in attendance?
Yes.
Hi, could you please introduce yourself?
Hi, good morning. My name is Teresa Fontieri, and I'm representing the actual requester, Ms. Laura Ramirez.
Thank you all for being here. All right, Ms. Novanario?
Through the chair, there is nothing inherently unethical about a school board member running a private business. There is also nothing inherently unethical about a school board member volunteering in her district's schools. But there are facts and circumstances that, together, could create a prohibited conflict pursuant to the Code of Ethics if a school board member who owns a private business volunteers in her district's schools on behalf of that private business. The facts and circumstances here work together to create such a conflict of interest. Lauren Ramirez is a recently elected Flagler County School Board member. She is also the owner of a private business that offers medical training, certifications, and courses to adults and children as young as 4 years old. She notes that prior to becoming a school board member, she regularly volunteered in district elementary, middle, and high schools on behalf of her medical training business. Examples of her prior volunteer activities included attending high school career fairs and discussing her business's phlebotomy and medical assisting certification courses with high schoolers, lecturing in classrooms on various health topics like the effects of too much sugar in one's diet, and demonstrating certain healthcare skills such as hands-only CPR, AED usage, and phlebotomy demonstrations using fake arms and fake blood. Ms. Ramirez reached out to the Commission on her own behalf, seeking guidance regarding whether there are any ethical prohibitions against either herself or her employees continuing to volunteer in district schools now that she is a school board member. Ms. Ramirez posed 4 separate questions to the Commission. Each question's analysis is primarily pursuant to Section 112.3137A, which prohibits conflicting employment or contractual relationships and contains 2 provisions. The second part of Section 112.3137A is the most pertinent here. It prohibits a public officer from having a contractual relationship or employment that will create a continuing or frequently recurring conflict between her private interests and the performance of her public duties, or that would impede the full and faithful discharge of her public duties. In her first posed question, Ms. Ramirez asks whether she or one of her business's other employees could continue to volunteer in district schools. Inherent in this question is another inquiry. Can Ms. Ramirez market her business's course offerings to students while volunteering by, for example, wearing shirts with her company's logo on them, handing out pamphlets or flyers about her business, or advising high school seniors on how to register for her certification courses? As noted previously, there is nothing inherently unethical about Ms. Ramirez's company volunteering in district schools. However, a conflict would arise pursuant to the Ethics Code if Ms. Ramirez marketed her business to district students or if district students ultimately signed up for or participated in any of her business's courses. The Commission has held in a long line of cases that a conflict pursuant to the second part of Section 112.3137A is created when public school teachers and school board members engage in secondary employment involving students over whom they have public capacity duties. School board members have public capacity power and duties over every student within their school district, and a school board member's participation in a secondary private business endeavor that caters to students within her own district creates a prohibited overlap between her public school board member duties and her private business's interests. That prohibited overlap creates a temptation for the school board member to dishonor her public duties by showing favoritism to those students who support her secondary business endeavor. We have held in CEO 0417 that a public school teacher cannot tutor her own students for a fee. In CEO 1015, we extended that holding to apply even if the teacher's secondary endeavor is for enrichment purposes rather than tutoring, noting a teacher could not offer a summer art camp for a fee to students in her own art classes. Similarly, in CEO 1321, we held an exceptional student education teacher could not, through his private business, offer a therapeutic social skills course to students to whom he taught or to whom he had responsibilities. In CEO 1427, we extended those holdings to apply to school board members by determining a school board member's private tutoring business could not provide tutoring services to students within her district. Here, Ms. Ramirez's company caters in large part specifically to children, with course offerings available for children as young as 4 years old and medical camps and trainings offered to children as young as 11. And the unique nature of the business, medical training, necessarily requires Ms. Ramirez or her employees engage in extended, hands-on interactions with the children participating in the offered courses. Under these specific and unique circumstances, where Ms. Ramirez owes a public capacity duty to each district student, and where the nature of Ms. Ramirez's business is geared towards children and fosters relationships between herself and the students enrolled in her courses, should any district students enroll in her business's courses, Ms. Ramirez might be tempted to show preferential treatment to those students. Thus, we recommend determining that, though Ms. Ramirez may continue to volunteer on behalf of her business in district schools as a school board member, the second part of Section 112.313(7)A would prohibit her from marketing her business to district students or allowing district students to sign up for or participate in any of her business's courses pursuant to the second part of Section 112.313(7)A. Ms. Ramirez next wonders whether she can hire district teachers or employees to work for her private medical training business. Specifically, she questions whether it would make a difference if her business provided the hired district employee with a W-2 tax form or a 1099 tax form. The analysis here is also pursuant to the second part of Section 112.313(7)A. The Commission has previously considered an analogous situation in CEO 1427 and determined that a school board member who owned her own tutoring company could not hire district teachers to work for her private tutoring company. We reasoned that the school board member's hiring of district teachers for her private business endeavor would violate the second part of Section 112.313(7)A, as the school board member had authority and responsibility over district teachers, and her hiring of a district teacher could tempt her to treat that teacher more or less favorably than other district teachers as her business's employee. In line with our prior decisions, we recommend finding that the private business's hiring of district teachers would violate the second part of Section 112.313(7)A because it could undermine Ms. Ramirez's objectivity regarding her official duties as a school board member, regardless of whether the district teachers were hired as employees or independent contractors, and whether they received W-2 or 1099 tax forms from Ms. Ramirez's business. Ms. Ramirez next questions whether her business can sponsor a district school's team if, in return for the sponsorship, the team places her business's logo on its T-shirts. In other words, can Ms. Ramirez's business purchase advertising space through a district team's fundraising effort without running afoul of ethical prohibitions? This inquiry requires an analysis under the first part of Section 112.313(7)A, which prohibits public officers from holding employment with any business entity that is subject to the regulation of or is doing business with the agency of which she is an officer or employee. The question is whether sponsoring a district school's team would equate to Ms. Ramirez doing business with the district. Pursuant to our precedent, if Ms. Ramirez's private business made a one-time payment to the school to support the team, that would likely be considered a donation and would not be viewed as doing business with the agency. However, where the school, in exchange for the business's sponsorship, puts the business's logo on team's T-shirts, we recommend finding that the placement of the logo on the T-shirts amounts to consideration in exchange for the donation, creating a contractual relationship between the business and the school that would amount to doing business with the school and would violate the first prohibition of Section 112.313(7)A. Finally, Ms. Ramirez wonders whether she can use the online platform Peach Jar to email flyers to parents regarding her private business's programs or events. If the Commission determines that the registration or attendance of district students in any of the business's courses amounts to a violation of the second part of Section 112.313(7)A, the Commission should likewise find that the second part of Section 112.313(7)A also prohibits Ms. Ramirez from marketing her business to district students, whether through Peach Jar or through any other platform. As a school board member, Ms. Ramirez has public capacity power over each student within her district, and a secondary business relationship between herself and a district student might create the temptation for her to dishonor her public duties by undermining her objectivity, depending upon whether a student supports that secondary business endeavor. The same temptation to dishonor her public responsibilities would arise if she were to market her business to district students. In summation, under this particular set of circumstances, where Ms. Ramirez's private business markets primarily to children, where the unique nature of the business requires ample interaction between the students and the business's instructors, and where Ms. Ramirez owes a duty to all school children within her district by virtue of her public position, we recommend the Commission determine that any district students registering for or participating in the courses offered by Ms. Ramirez's business would create a prohibited conflict of interest under the second part of Section 112.3137A. Ultimately, we recommend finding that though Ms. Ramirez can volunteer in district schools on behalf of her business, she may not market her business to district students, hire district teachers as employees or independent contractors, or sponsor school teams within her district if that sponsorship amounts to more than a simple donation. We offer this draft for your consideration, and I'm happy to answer any questions you may have.
Does anybody have any questions? Please.
Is this the mic I use? Okay. So your explanation was lengthy, but I think I got it. This does not apply to anyone she's ever taught or had in class. I mean, it doesn't go back to when they graduated or whatever. It's just those that are currently in the class or in the school.
That is correct, and that it would only apply to students that are currently within her district. So once they have graduated, they can register and participate in the courses. And also, if they are from a different district, they could register and participate in her courses. The issue arises because her public position is within her district.
Madam Chair, I have a question. The courses that she's teaching, do they reflect in the student's academic transcript, or are they kind of tertiary to their record in the school system?
They are not a part of the typical, it's sort of like an extracurricular activity. They're not a part of the school course offerings, so they would not be reflected in the transcript.
If we were to, like, say it was sports coach, like they were completely different case and it was like a baseball coach, softball coach or something, do you think it would be the same recommendation?
We do actually have a case on point where there was a coach, and we have held in the past that a coach cannot coach independently outside of the school any students that are in his, for example, PE classes, or that he has any public duty responsibilities towards. So, for example, if that coach was also a teacher, he could not teach any of those students who were in his course. We have held that in the past.
But he has direct grading of them. You're saying you would extrapolate that probably up to even the school board member for the entire district?
Yes, and we have held that also in 1427, and the issue is that as a school board member, Ms. Ramirez does have a lot of power, and she does have a lot of responsibility to each individual student. So she could be voting on individual student matters, such as suspensions, ESE accommodations that are particularly pricey, those things that could really affect a student's trajectory in the future as well.
With CEO 1427, that was with regards to tutoring by a board member?
Yes, I was a school board member that owned a tutoring company.
And tutoring can be a short term, could be a long term, it could be just for a semester, correct?
Yes.
And in this situation, the applicant's asking about medical camps and what other activities that her service provides, CPR training, medical camps.
That might be a better question to ask her as well,
Okay.
since she is present today, but my understanding is that there are medical camps, CPR training, certification courses, babysitting certification camps, and then for some who are 17 or 18, there are certification courses like phlebotomy and things like that.
But like tutoring, like training of a coach, those are short-term. They can be short-term as well.
Yes.
And based on CEO 1427, we've said that would constitute impermissible activity.
We have, yes.
Thank you.
I mean, if someone owns, if a school board member owns a restaurant, are students not allowed to patronize that restaurant?
The analysis under section 112.3137A is going to be very factually specific. What makes this case particularly unique is that Ms. Ramirez is a school board member. She owes a public capacity duty to each student, and her business, the main clientele of her business are really students. If a school board member owned a restaurant, it would depend on what kind of restaurant this was. But the case at hand is not, for example, a Wendy's where you're going through a drive-through, it's anonymous, we're not really sure who's purchasing. The students in this case register for classes, they go to the classes, they attend the classes, they have at least one interaction with an instructor there. So there would be a sliding scale of these analysis of this kind of question, I believe.
What if it was a Chuck E. Cheese? It's a serious question.
It is a serious question and a good one. I think it depends on, I think it would depend on a number of factors that we would have to ask and get more information about, like hosting birthday parties versus just going in and sitting down and eating a meal for a one-time thing.
And I think and I really am, I'm not trying to be smart. The marketing to students, no issue. I understand that. I guess it's just the idea that students aren't permitted to, of their own volition, go pursue this opportunity, or or she has to make the choice that her business is going to suffer because students want to make a voluntary choice. I think that's the part that I'm wrestling with.
The issue arises because of the conflicting employment or contractual relationship, as you said. So Ms. Ramirez could have a couple of options. She could choose to no longer be on the school board, which is not ideal for anybody. She could also choose to give her interest in her business to, for example, her husband, and then she would no longer have that contractual relationship or employment with her business, so there would be no conflict under the second part of Section 7A.
I mean, I understand the opinion. I don't like it. It's confusing. It seems to be the response is pretty much no. And if I were a school board volunteer, I would step down so I could continue to operate my business. I mean, it's not that she's even targeting tutorial activities for academic requirements in school. These are, the medical training has nothing to do with any course requirements in school. So I'm troubled by the application. So I'm not suggesting that your application is somehow logically erroneous. I just don't like the practical effect of it. And the practical effect seems to discourage people who could meaningfully volunteer as school board members from doing so.
Are there any other questions at this time?
Madam Chair. On that, if I may, on that point, I think the one thing that this opinion does do, if we're worried about the practical effect of it, is it doesn't draw where the line is on that spectrum, right? On one end of the spectrum, you might have a Wendy's with a drive-through where the business is anonymous and the clientele is much larger than the school district or much larger than children. And on the other end, you might have, like one of our opinions, the tutoring business, right? And then every other business is somewhere in between. What we've not done in this opinion is said exactly where that line is, because it's not really clear from our other opinions where that might be. What we've said in this opinion, though, is we feel like in this case, with this business, that the answer would be that there is a prohibited conflict. So what we would probably need is for other people where they have businesses that are different, and every business is going to be unique. As we get more opinions in this area, the line will become a little bit more clear. The question that she asked is particular to her. It's finding advice to her.
And in that regard, Ms. Ramirez, thank you for submitting the request. Thank you. An ounce of prevention is worth a pound of cure. So thank you for making the trip here today.
I think we'll have a chance to discuss further, but let's give Ms. Ramirez and her counsel opportunity. Thank you.
Good morning, Commissioners. May I approach? I have just a little bit of a demonstrative for you all. May I approach? Or do you want me to give it to somebody else? It's just a little pack of papers.
As long as we can consider it. Yeah, I mean, I'm fine with it. I just know sometimes in like the quasi judicial stuff, you tell me I'm not allowed to look at stuff.
Good morning, Commissioners. Thank you so much for considering this opinion. Thank you for your time. My name is Teresa Pontieri. I'm an attorney by trade, so if I accidentally call you Your Honor, congratulations on the promotion. It was not purposeful. It's just a habit. Being in this beautiful place, it's hard not to go there. Just as a little bit of a backstory, I want to first start by clarifying a few facts with regards to Mrs. Ramirez, because I think that your questions go directly to what's very important in this case, which is there are factually distinguishable facts from this case versus some of the other CEOs that were cited in the draft opinion. First and foremost, Ms. Stephanie said during her presentation that, quote, under this particular set of circumstances where the business caters directly to students, there is a found conflict. And the truth of the matter is, and what we just presented to you in this packet of papers, and this is data that was pulled directly from registration numbers from Mrs. Ramirez's, her registration platform, only 30% of her clients are actual students. Out of those, 59% take her babysitting class. Out of those, 90% are out of county. So they're not even in her district. So we have actually a very small percentage of her clients that are students within her district. And why that matters is all of these opinions state that there must be a continuously and frequently occurring conflict. We simply don't have that in this case. And to your question, Commissioner Lucas, it goes directly to that dichotomy of cases where you can have a continuing and recurring potential conflict, and then you have the instance of Mrs. Ramirez, where that just simply doesn't exist based on the actual facts of her circumstances. And all of these opinions, which they've stated fairly, are very fact-specific. And to your question, Commissioner Rogers, and your question, Commissioner Phillipson, when we're talking about some of these other opinions, the STEM course opinion, which was opinion 14-27, that was directly on point with STEM classes. Things that, to your point, Commissioner Rogers, are part of the curriculum. These are CPR, babysitting, and phlebotomy classes. These have nothing to do with her curriculum. Mrs. Ramirez has no ability whatsoever to affect curriculum, to make decisions on a student's curriculum that have even a tangential relationship to the courses that she teaches. So we do see a very big difference in this case between the draft opinion and what we have in Mrs. Ramirez's case. Going to come of the summary of our position on the draft opinion, we agree with some of the findings in that draft opinion. Specifically, we agree with the opinion in that Part 1 of Florida Statute 112313 is not at issue and creates no conflict. Rather, it's Part 2 that we should really be looking at. We also agree that a sponsorship that comes with a return benefit, such as logos being displayed, would create a conflict. Finally, we also agree that while volunteering creates no conflict, she should not be marketing her business directly to students. So those we have no issue with. What this really comes down to is whether Mrs. Ramirez can still have in her classes students from her district, and whether or not teachers, as a second job, which we know many teachers have, can be instructors for her company. I also think it's very important to point out from a factual standpoint that Mrs. Ramirez does not teach her classes. When she began campaigning as a school board member, to which she was elected last November, she actually delegated the teaching duties because she wanted to focus strictly on campaigning, and she has kept that delegation in place because the school board position does take a lot of her time, and she now focuses strictly on running kind of the operational side of the business. So she has absolutely zero face-to-face interaction with her actual clients. And I call them clients because I don't want that to be confused with students, being that 70% of her clientele are actually adults. The key difference between the ethics opinions cited and our case is that the recurring phrase used throughout the various opinions, which is that creation of a continuing or frequently recurring conflict, which we do not have in this instance. There are key distinguishing facts from the other ethics opinions and factual clarifications regarding Mrs. Ramirez's business, of which I just mentioned. The packet in front of you clearly shows that 70% of her clients are adults. Actually, 9 of the classes that she offers are for adults. Only 4 are for youths. And I think what's also really important, this goes to some of the questions as well. I believe it was yours, Commissioner Rogers. These classes are from anywhere from 1 hour for the youth CPR class to 4 days, which is the summer camp that is offered to youths. There's nothing else that goes any longer than that. None of her classes expand past 4 days for youths. Additionally, the only classes that require a recertification are the adult classes. So in some of the adult classes, they have to come back 2 years later for recertification, but none of her youth classes have that requirement. I think that's really important because there's no potential, in other words, that a student that does take her class will come back, or this can't be recurring business, in other words. It's kind of a one and done deal. So even if she were to have a student from her district take one of her classes, of which she has no face-to-face because she doesn't teach them, there would be no potential that they would be able to financially benefit her again by coming back for a recertification. Now, it's possible they could candidly take another class. In other words, if they enjoyed the CPR class and wanted to come back for the babysitting class, sure, they could do that. But again, she has a client list that lists 270 clients or however many it is that she has, and that's all she has access to is just that client list. Matter of fact, when they sign up, they don't even specifically list where it is that they, like what district they're in, whether they're in St. Johns County, Flagler County, whatever it may be. The only reason we were able to extrapolate the data that you have in front of you right now is from that platform PeachJar, because it can pull some of that data from PeachJar if she wanted to. But it's not a question that she asks of her clients when they sign up, so that she can see it on the front end and say, hey, this is a student from my district. I'd like to specifically go to one of the opinions. I think it's very important to look at this specific opinion. This is CEO 4-17, which states there's no conflict of interest for a teacher to engage in tutoring activities for a fee as long as the teacher does not tutor his or her own students. And if we look directly at this opinion, the summary says there's no prohibited conflict of interest that would be created under 1123137 Florida statutes if a teacher were to engage in tutoring activities for a fee on school grounds where the teacher is prohibited from tutoring his or her own students and is subject to the same requirements for leasing the facilities as other entities. I think what's flawed about comparing this opinion to opinion 4-27 is that we're assuming that a teacher can tutor students as long as those students are not in the teacher's class. But I feel that concept is a little flawed when we then say, because that teacher only has purview over those students, those are the only ones they can't teach. And because Ms. Ramirez has purview over the entire district, none of those students can take her class. And here's why I say that. We know that teachers on a day-to-day basis do not just have purview over the students in their class. They monitor hallways, they supervise lunch hour, they supervise bus lines. If any student acts out during any of those times, a teacher has the ability to discipline them, to reprimand them, to have some type of authoritative power over them. A teacher does not need to have a student in their class in order to exercise a purview over that student. By virtue of the fact that the student is in that school and the teacher may be supervising them in some capacity, they have the ability to exercise some authority and control over that student. So to say in Ms. Ramirez's position, because she technically has purview over the entire district, none of these students can take her classes that are completely unrelated to curriculum. is just too far-reaching. We're going too far. And to the commission's point, that would very much preclude a lot of people who are willing to serve on not only school boards, but and candidly, commissioners, I'm a city council member, I'm vice mayor of the city of Palm Coast. It would preclude many public officials from being able to serve in some capacity and also have private businesses in which they earn a living and put food on their table. And so I would ask this commission to look very closely at the specific facts of this case and consider the fact that teachers, by virtue of this opinion, you're saying that teachers can only teach students that are not in their class without considering the fact that they also have some type of authority and control over students that are not in their classes as well. I'd also like to point the commission to 4-27, only to point out the fact that that was involving STEM, and I think that that's a very different scenario than we're looking at here because of the close relationship between those types of courses, the curriculum, the fact that a school board does have some more control over certain types of curriculum than we are looking at in this case. From a factual standpoint, also, it's important to note that Mr. Maris has very limited capacity in what she does with students. So really, the only time a specific student's situation would come before her school board is if there was an expulsion. There's only a 0.06% chance that that happens. Only 0.06% of the students in this district get put up for expulsion. So when we look at that, and we look at the fact that her courses are not predominantly catered towards students, and in fact, the data shows that there's not a majority of students that take her courses. The chances of there being this recurring and continuing chance of a conflict just simply does not exist. Furthermore, when we look at the interaction with teachers, the only time that really something comes before her that she has to vote on with regards to teachers is if there's an appeal of a termination. Again, something that does not happen very often. I think that these facts are very important, and when we look at, there was also a mention of, and in our response specifically, of abstaining from a vote pursuant to section 1123143. The reason we brought that up and the reason we think that that needs to be considered by the commission is that Mr. Ramirez can only make decisions that affect specific students and teachers by virtue of a vote. There are not decisions that she can make specifically with regards to the courses that she teaches that would have any effect on specific teachers or students without there being a vote. In other words, she can abstain from a vote and avoid any potential conflict in the very rare circumstance that it occurs under her specific set of circumstances. I would like the commission to more closely align this set of facts with some of the opinions that were referenced in the draft opinion where a teacher actually was, there was a question as to whether or not there would be a prohibited conflict of interest if an athletic supply company was owned by an assistant superintendent of a school district and by a high school principal within the district to sell athletic supplies to the students and teachers. And that is CEO 80-35. And in that opinion, it says that no, there's no conflict. As a superintendent, as a principal, you can sell athletic supplies to students, directly to students and to teachers, but you can't market to them. And we don't have an issue with that. We have no issue with her not specifically wearing her logos when she's volunteering in the schools. We have no issue with her not specifically handing out flyers at the school. We completely agree that that could create a conflict. But we believe that in her situation, it's more analogous to this athletic equipment being sold pursuant to 80-35. There's also another draft opinion, and forgive me, I'm having a hard time finding it, but it is with regards, oh, here it is. This is CEO 10-12. This says there's no prohibited conflict of interest under section 112.313, specifically 7A Florida statutes, if a school board member were to be employed as president, a school board member, as president of a school uniform company where they are a designated preferred vendor and they have to wear uniforms. This school board member was a preferred vendor that sold the school uniforms to students. And the commission found that there was no conflict. And it says, because the school board's authority over its personnel, a school board member would be prohibited from personally soliciting the school district personnel and the school-related organizations like uniform companies, but to simply sell the uniforms, there's no conflict of interest. And again, we ask that this commission find that that is more analogous to what we have here. And in that case, we even think there's even more of a potential of a conflict because those students presumably are going to purchase more than one uniform. So, that has the actual ability to be a recurring business for that school board member, yet there was found to be no conflict. I will conclude, Commission, by saying that I think it's really important that we do look at the pragmatic and the practical effects of today's result and today's opinion. And I'd like to just read the last bit of Ms. Ramirez's response because I think it's really important and it highlights those pragmatic effects. She says, the pragmatic effects of your response will not just be felt by myself and my community, but will have far-reaching effects on any and all public officials that serve their communities while also earning a living as small business owners in their communities. Surely the legislature did not intend to prevent public officials from providing services or earning a living, which is the real-life result your response would have, not only on me, but on many others. While we are public servants sacrificing on a daily basis in order to serve, I fear such broad restrictions would preclude many who are capable and willing to serve from doing so due to the inability to then provide for their families due to having to give up their businesses or other professional careers. I do not think this is the intent of either this committee or the legislature. Again, when we look at the fact that throughout the opinion, we see that these are very fact-specific, and it has to be based on the specific facts of the case, and that there must be a continuing and recurring potential of a conflict of interest. We find that, or we hope that you all find that beneath Florida Statute 112313, that there is no conflict in the final draft opinion. And with that, I welcome your questions, and Mr. Ramirez is here as well.
What was the number, the opinion number of the school uniform?
That, ma'am, was, I believe, 10-12. 10-12. Yes, Commissioner.
Yes. Does Ms. Ramirez offer her services on school grounds, or is there a separate facility that she provides?
It's a
these
separate
services?
facility. It's completely unrelated to
And you would
school
agree
grounds.
that offering services that is not on school grounds may create a conflict, but at a separate facility is a distinction?
Well, in the tutoring course, the tutor, where they said that, and this was draft opinion, where they said that the tutor was able to provide services on school grounds as long as it wasn't their students, there was no issue with that. That's opinion 4-17. So I don't know, candidly, I don't know the answer to that question, but in this case, she's not offering those
It seems to me that
services.
there's a distinction between school grounds and off premises that shouldn't be ignored, but in reading the draft opinion, it seems to make a fundamental error as well in saying that she caters predominantly to children.
Yes, sir.
Which the information that you provided doesn't support that. So I'm not sure why that statement is in the draft opinion, if it's in fact erroneous.
I can help clarify that if you'd like me
Sure.
to. I think when Ms. Ramirez, because she made a phone call and said, hey, this is what's going on, I'm looking for some guidance here, and she referred to all of her clients as students. And so I think that interchangeable language was probably the source of confusion there, whereas really, I mean, technically, are they students of her courses? Yes, but we shouldn't use them interchangeably because they're holistically, they're clients of her business.
In the summary of the draft opinion, there's some language of the school board member or employees may not market or promote the private business while volunteering at the school. That, my understanding is Ms. Ramirez would be okay with that.
She's totally fine with that, yes, sir.
And that seems to be a very narrow, specific to these facts, specific to the situation versus a broader, she couldn't even put a flyer up in the YMCA of the town.
Yes, sir, I agree.
Or any other questions?
If there are no further questions, I thank you so much for your time, and I apologize, Commissioner Lucas. Did you have any other questions, or?
Oh, no.
No, okay, I just
Thank
wanted to
you.
make sure. Thank you so much for your time and consideration this morning.
Thanks. Is there discussion on the draft opinion from the members, or is there a motion?
Madam Chair, discussion. There's a lot here that has some really, really big impact if we take the opinion as it is. To your point on the restaurant, I wanted to hear, but same thing. And then two other things to consider. If we're going with an opinion that hits this broad, we're talking students of the district, but any child in a geographical area is now can be affected by, like, homeschool kids can do sports at schools. Private students can do stuff at school. So it grows pretty rapidly. And to the point on the students have parents. So you might say something, well, can any parents take classes at a non-academically affiliated program, or coaching, or eat at a restaurant? So, like, it's a sliding scale, I think, and that sliding scale can get very, very overly government restrictive, I think, on what's available there. So I'm just trying to piece through the 4 different items in here. There's a few of them, but it can become very, I would say, restrictive for anyone doing any type of public service, depending on how far you take that. I'm still thinking about it.
I don't know if it's appropriate to move at this time. Do we have any further discussion? I mean, I will just say I'm troubled by the draft of the opinion. I think we should reconsider in light of the discussion today. And I don't want to make a motion yet, but my suggestion would be that we reconsider this and have further discussion about it. But I'm not ready to make a motion yet.
I do think that the statute itself is troubling, and that we should really go back to the legislature and try to make the statute a little clearer than what it is today, because we're going to be seeing these things possibly over and over again, case by case, and we might be able to do a better job if we adjust the statute itself. But I'm in favor of supporting your recommendation.
I agree with the fellow commissioners. I think the opinion casts a wide net, and that we need to take a scalpel approach in this situation. And I agree with Commissioner Stewart that maybe it's a legislative fix, but adopting this opinion would have a floodgate effect, and I think would inhibit people from wanting to do public service.
I agree, and I think that it's one thing to just not like the practical impacts, but that happens every day. But I think one thing that I found compelling is setting aside the lack of, the statute's obviously got a lot of room for discretion, and but the discussion of opinions 80-35 and 10-12, which I candidly I didn't read those before this meeting, and I apologize. But just the discussion of those, I think, gives me reason to think that maybe there is some reconsideration to be done on what the proper analogy is to draw. So if they're, I agree with what everyone's saying.
I'd like to make a motion, Madam Chair, to, at this time, not adopt this opinion.
Let me move to, can I make a concurrent motion, or what's the procedure? Do we need to have a second?
Not sure.
There wasn't a second.
If there
I don't know
is,
that we were ready to close discussion.
if you're wanting it, some sort of redraft, if you have, direction for the legal staff.
Yeah, I would move to reject this opinion as drafted and direct staff to redraft the opinion in light of the information provided today.
Second?
Steve?
I've been listening to the discussion. I think I can, and I want to make sure that we give proper guidance to our staff here as we go to redraft. So what I think that this would look like, what the redraft, in my mind, based on the discussion, would look like is, what we've seen is a discussion about facts, not really about law. I understand that everybody's identifying maybe a problem with the law, but really what we've been discussing are a lot of facts that we didn't actually have in the request that we now have, and that, based on your discussion, you find them to be material, and we would write a draft based on those facts that says this business is no conflict for selling. There's lots of other questions besides the selling, which we focused on. And so I would want to make sure that we have clear guidance from you on some of these other questions. It sounds like the requester, and I didn't hear a lot of discussion from you all about the marketing of targeted to students in the school. It doesn't sound like we discussed, at least you didn't discuss, the hiring of the teachers for the business, either as employees or as independent contractors. So we don't have guidance yet from you as to what the will of the board is on those matters.
So neither of the current motions have a second.
No, I think we,
Oh, there's a second to the left.
I seconded.
So can we still provide clarity
yeah, we can still discuss.
on that? Okay, so my takeaway from the discussion was that the only item that I think needs to be revisited for further discussion would be the selling or allowing students, district students, to register and take the classes, and that everything else would remain undisturbed, but by all means, if that's not correct.
Madam Chair, yeah, I think each of these are pretty big. I think on the selling direct, and it grows fast, so we're saying on that. On the hiring teachers, I don't know that I would prefer it to be looked at a little bit more that versus like saying just adopting that right now. I think that one's a little more specific, and some cases were made. On the marketing to students, I mean, I think if you're using your office or your access to market to students, that's clearly a problem. I don't think that's what's here, but if you're saying, again, taking to, like, can you put a billboard up that students will look at versus can you send, do you have to make sure if you're marketing to a big body of folks, how far down the line do you have to go to make sure students get pulled out of that versus sending a targeted list directly to students of only that school district? That's I think that gets a little tricky as well, and the opinion is written. I don't know if it takes enough of a scalpel, I would say, to it, but it's a little bit more nuanced.
My suggestion was we just take a look at this as separate issues rather than lump them all together, and then we address the issues separately. I think we're trying to do too much in just one opinion. So if you want to, that would be my suggestion as part of asking staff to go back and take a look at this. So I'd like 4 separate opinions if we're going to address 4 separate questions, and then readdress them in light of the information that's been provided today. I'm also troubled. I don't like the idea that you can't put a logo on a shirt. I think it's silly, but I don't know what the opinions and the statutes are going to provide for that. So.
I agree with you, Commissioner. I think it should be 4 separate opinions. And with this particular opinion we've been focused on today, I believe giving a little bit more deeper analysis to CEO 1012 and CEO 80-35, I believe, were the 2 opinions, and how that interplays with this fact pattern, and giving that a little bit more analysis.
But the interesting thing about opinion 10-12, and Stephanie would be more than happy to dive into this since it's relevant, but CEO 10-12, you've heard, and for those of you who are new, you may have less experience with this, but 112.3 subsection 7A has 2 parts to it. When you look at it, it's this long sprawling paragraph, and there's a semicolon right in the middle. And the first part of it, they both deal with what we call conflicting employment or contractual relationships. And the first part of it is what we call a dynamic-based conflict. Like it essentially prohibits a love triangle between the public officer, the business that they have, the business entity that they have employment or contractual relationship, and their agency. So if they have employment or contractual relationship with a business, their own business, for example, and that business is doing business with their agency, you have a triangle, that dynamic stands in for the proposition that there is a conflict, and then there are a bunch of exceptions, right? That's the first part. And 10-12 provides a thorough analysis of the first part of 112.313 subsection 7A. And then it is silent on the second part of 112.313 subsection 7A, which is what our draft is about. Our draft is about the second part, which again, the second part of the statute looks more at the reality, rather than just saying that if you have this dynamic, you have a de facto conflict, and then we'll look at exceptions. The second part of the statute looks at the reality of the situation. What it says is, if you have any contractual relationship or any employment, and if it will impede your ability to do your public responsibilities, make you less than objective in your public role, if it will create any sort of continuing or frequently recurring conflict in your ability to do your public role, then we would say that a conflict exists. What we have here, and the reason why the draft looks like what the draft looks like, is we have somebody with a business who's saying, if I can't sell to the students in my district, it's going to impact my district in a major way. It's going to impact my business in a major way. And if it's going to impact the business in a major way, then they have an interest that they might put ahead of their public responsibilities. And that's what the draft is really looking at. I understand it's only 30% of the students, but what we're hearing is it could affect the business in a major way, such that what we're talking about is it sounds like an existential question for the business, even though it's only 30%. If that is the interest that's at stake, what we would say is maybe that has an effect on the public decisions that might get made. If a parent calls up a board member for constituent services, that parent might be right to expect that if they did business with the board member, that they might be able to, that they might be right to hope that it might help with whatever matter they're trying to get done, the scheduling for their kid, accommodations issues, or whether or not they want to move from one school to another. School choice didn't work out, we want to get to another school. There's lots of things where constituent service type things where a parent is going to call up a board member. It's not just even voting matters, right? So the draft is looking at all of that. And the second part of 7 kind of takes that whole universe of all these other concerns and says, is there a temptation, not even does she have the strength of character to resist the temptation, but is there a temptation that those realities, whatever they might be, that they might affect the faithful discharge of the public responsibilities? And 10-12 doesn't even devote a sentence to it.
From a practical standpoint, I think the questions that everyone has and the concerns everyone has are with questions 2 and 3. But 1 and 4, I haven't heard any issues with. I'm just trying to clarify for staff. I mean, is that Stephanie and Steve, do you guys agree with that breakdown? Like,
we think maybe you got the questions misnumbered. So
probably.
question 1 is about volunteering, and it addresses selling as a premise. Basically, the elevator pitch for question 1 is, you can't really market if you can't sell in the first place, we don't think you should be able to express a commercial willingness to sell and market if you can't sell in the first place.
Yes, you're right. So I was just thinking of the actual volunteering, but no, I understand. So yeah, so it's 1 and.
Question 1 and then the peach jar question are really the same question.
Okay.
That's 4.
And then 2 is hiring teachers. 3 is the logo. All right, so I guess we have, I was trying to make it easier, more streamlined. It's just not.
I think it's
all
really
4.
I think it's 3
or 4.
questions. I think
Okay.
1 and 4 are the same.
Okay.
And we could lump those together pretty easily because they're essentially, when you look at question 4, it's just pointing back to question 1. Question 2 is the logo.
District teachers.
Oh, the district teachers. I don't know that we've reached a consensus on that yet. And then question 3 is the logo, which is a first part of 7 analysis, right? So when we were talking about the dynamic, so again, the elevator pitch for question 3 is, you have an individual, they have a business, the business is doing business with the agency, and that doing business is, we will give you money, and in exchange, you get a logo. If it would, and the opinion is very clear, if it was just a donation without the expectation that something be coming back, there wouldn't be consideration. And in the absence of consideration, you wouldn't have a doing business relationship. And that's all question 3 is saying. That dynamic is present because something is going one way, the money's going one way, the logo's going back the other way, the advertising, the marketing is, so it's one in exchange for the other. That's doing business. There is the dynamic. There aren't any other exceptions in the statute that are applicable, and therefore there's just a prima facie conflict without an exception to first part of 7A. We don't even address second part of 7 there because we already have a conflict. That's what the question 3 is about.
I'm reading the definition of doing business from 22-1. So if I give a donation to my school with the expectation, my kid's school with the expectation that my logo is going to be put on someone's uniform or on a vinyl or something on a sports field, and they don't do that, can I sue them? Do I have a cause of action? Because it says that
We're
we have a
concerned that
cause of
there might be,
action.
if that's what the offering is, in fact, your mileage is going to vary based on facts, right? But what we're concerned about is exactly that. And that's why there's a conflict of interest that would prohibit the business entity from doing business with the agency.
Is there a statutory definition of doing business?
There is,
I'm sorry for dominating.
we have a lot of
That's a good
opinions
question, yeah.
about it, and as the summary of those would be any relationship that would create a cause of action or any relationship where there's an exchange of consideration.
So I think the exchange of consideration is a little too broad, and in my opinion. And maybe I'm legally wrong, but it just seems that it's overreaching here. We're just using a big broad brush because you're donating and you're getting your logo on. It's advertising, but there are no services that are being provided. So
It certainly has value to buy the advertising, essentially, is what they're selling here. If she wanted to, for example, we've kicked this around the office, and, we move court these things in the office. If she wanted to buy her own shirts with the logo and donate shirts, for example, right? That's a donation of materials. That would be not doing business, right? That would be a donation. She could do that, and then we just have the marketing question, which is now, and then we would have had a second part 7 analysis, which I don't know, as I sit here right now, I don't know. But first part of 7A, we wouldn't have a doing business situation there, and that could have happened. And we say that in the opinion. She could make a donation of money, donation of chattel would have been the same.
Well, I think because we're having the confusion we are with the questions and the discussion, again, my motion was that we direct staff to redraft this as 3 or 4 separate opinions, if you want to lump 1 and 4 together, and that we then address it again at a subsequent meeting.
Second.
What I think we could do, Commissioner, for you, because we don't have some direction on some of these, what we could do for you is maybe put an A and a B version together on some of these, where you can see on paper what these things might look like. And then you'll be able to vote on A and B for question 1, A and B for question 2.
Okay.
I think that would be helpful.
Do we want to see the opinions too, the previous opinions first? I think that those weren't part of our materials.
Yes, could we, as part of are they attached?
Yeah, maybe we could have them attached.
Are
to
they-
Like the
We'll
analysis of
solicit the
them.
handout
Yeah.
so that we make sure that that's included in the materials.
Like when we get our prep materials, they're in there, right?
I didn't see it,
Were they
80-35,
not?
They
and
should be on, you have a commission laptop, the opinions are on
Oh,
the desktop. You can access the
but-
opinions, they're on the desktop, but they're not included as a part of the packet.
Could they
And
be
if that's
included as
something
part
that
of
you
the
wanted to do,
packet?
absolutely.
We'll give you all,
I think
all
that'd be-
everything that's
This is
cited. We'll
background.
give
Because
you
I
all
use
the-
my,
Yeah.
this means work laptop apparently, to,
Yes, we can attach those as a part of the.
which now I'm
materials.
afraid to even say.
all right. All right, so I guess we got a motion.
Okay, so Motion second, and then it would be presenting A and B. Okay. Is there any other discussion? All in favor? Aye. All opposed? Okay. Thank y'all for being here. And thank y'all, Stephanie and Steve, for fielding our questions. Appreciate it. My fault.
That was messy.
Okay, so the next advisory opinion was 2821, but that's going to be continued until the September meeting. So now we'll move on to file 2822. So are there any commissioners that need to make a disclosure on file 2822? Is the requester for 2822 in attendance? No. No? Okay. All right, go ahead, Ms. Naomi.
Thank you, Madam Chair. So Mr. Jacob Horowitz is an attorney who has requested an ethics opinion regarding gift acceptance and disclosure on behalf of a member of the City Commission of Cooper City. In his inquiry, Mr. Horowitz first asks about the application of the gift law to scenarios where a city commissioner receives something of value by virtue of his use of the discretionary funds allocated to his office by the city. To provide some background, Mr. Horowitz has indicated that as part of the yearly budget process, the City Commission allocates certain discretionary funds to the office of each elected city commissioner to be used for a public purpose in furtherance of his or her elective office. Mr. Horowitz noted that members of the City Commission have control of the discretionary funds assigned to their offices and may utilize such funds in accordance with applicable laws. Mr. Horowitz has explained that from time to time, and generally during the public budget process, charitable organizations approach the city and request public funding to assist with their various missions and objectives. Mr. Horowitz noted that many of these organizations provide social services and other community benefits, which reduces the burden on public resources and other public programs. As such, he has indicated that members of the City Commission occasionally allocate some of the discretionary funds assigned to their offices to these various charitable organizations. Specifically, Mr. Horowitz relates that sometimes officials will make a sponsorship contribution to a charitable organization by purchasing tickets to a charitable event hosted by the organization, utilizing the discretionary funds assigned to their offices. In his inquiry, Mr. Horowitz makes reference to CEO 19-17, in which the Commission opined that tickets to events hosted by nonprofit or for-profit entities are considered gifts from a city that are subject to disclosure when they are paid for by a city via a sponsorship purchase and then given by a city to public officers and employees who are reporting individuals. Now, however, Mr. Horowitz asks if the analysis in CEO 19-17 would be different, where a city commissioner individually makes a sponsorship to a charitable organization by using the discretionary funds assigned to his office to purchase tickets to a fundraising event hosted by the charitable organization. So before I get into the analysis, I just want to emphasize that this first piece of the opinion is only addressing whether tickets purchased with discretionary funds are considered gifts. Now, relevant to this inquiry and impertinent part, Section 112.312, subsection 12A, Florida statutes, defines the term gift as that which is accepted by a donee for which equal or greater consideration is not given within 90 days. This includes entrance fees, admissions fees, or tickets to events, performances, or facilities. So because the statute specifically includes tickets to events in the definition of the term gift, any tickets to an event which the commissioner accepts and for which he does not provide equal or greater consideration within 90 days are considered gifts to him. Thus, it must be determined whether a sponsorship made using the commissioner's city-allocated discretionary funds counts as consideration given by him for the tickets. So in the scenario Mr. Horowitz has described, the commissioner is receiving the tickets as part of purchasing a sponsorship from the charitable organization. However, because the sponsorship purchase is coming from the discretionary funds allotted to his office by the city, rather than from his personal funds, we do not view that as the commissioner providing consideration for the tickets. Rather, it is the city that is providing consideration for the tickets, as city funds are being used to procure the tickets, and the commissioner is ultimately receiving them at no actual cost to himself. As such, the tickets the commissioner receives in the scenario Mr. Horowitz has described will be gifts to him unless he personally provides equal or greater consideration for them. Now, because the tickets the commissioner receives in this scenario will be gifts, we may now turn to section 112.3148, subsection 8, Florida statutes. Essentially, this provision requires a reporting individual or a procurement employee to disclose all gifts he or she accepts that are valued in excess of $100, absent certain exemptions. The disclosure must occur by filing a CE Form 9, quarterly gift disclosure, by the last day of the calendar quarter following the quarter when the gift was accepted. Thus, where the ticket's value exceeds $100, the commissioner must disclose them on his Form 9. Now, Rule 34-13.400 subsection 3 in the Florida Administrative Code governs how the commissioner should properly disclose the tickets he receives on his Form 9. Now, relevant to this inquiry, the rule states that the commissioner must disclose, among other things, the name and address of the person making the gift. Now, because the commissioner would be receiving tickets from the charitable organization by virtue of an action taken in his public capacity on behalf of the city, namely the allocation of city funds, he initially will be taking receipt of the tickets in his public capacity on behalf of the city. For this reason, should he decide to use the tickets personally, it will be the city that would be considered the donor of the gift rather than the charitable organization. Thus, for purposes of the commissioner's Form 9 disclosure, the commissioner will have to report as a gift from the city any tickets he accepts as a result of his allocation of city funds, assuming their value exceeds $100. Now, in his inquiry, Mr. Horowitz asks if the answer to this question would change were the city commissioned to publicly approve the purchase. However, the analysis I just went over would still be applicable were that to occur, as the commissioner would still be receiving tickets for which he personally provided no consideration. Now, the second question Mr. Horowitz's inquiry relates to an event hosted by the Broward League of Cities. In his inquiry, Mr. Horowitz has noted that the city of Cooper City, along with almost all other municipalities in Broward County, is a member of the Broward League of Cities. Mr. Horowitz states that the Broward League of Cities is governed by a board of directors, which is comprised of elected municipal officials from each of its member municipalities. In furtherance of this organizational structure, Mr. Horowitz has indicated that the city designates one of its elected officials to serve as the city's voting delegate on the Broward League of Cities board of directors. Mr. Horowitz noted that the city commissioner on whose behalf he is requesting this opinion is the city's voting delegate to the Broward League of Cities, and thereby is also on the Broward League of Cities board of directors. Now, Mr. Horowitz has stated that each year, the Broward League of Cities hosts an annual installation gala where it installs its new president and swears in the delegates from each member municipality to the board of directors. Mr. Horowitz indicated the city purchases a sponsorship to the annual installation gala each year, which includes a number of tickets to the event. The city has historically offered 2 tickets to each member of the city commission, including the commissioner who is the voting delegate on the board of directors at the Broward League of Cities. Regarding this installation gala, Mr. Horowitz also makes reference to CEO 19-17, in which the commission analyzed a similar scenario and concluded that complimentary tickets to an event were a permissible gift received by city commissioners from their city, which would need to be reported if the combined value of the number of tickets received by a particular reporting individual exceeded $100. But now, Mr. Horowitz has asked if any of the exemptions from the definition of the term gift found in section 112.312, subsection 12B, are applicable to bring the tickets to the Broward League of Cities installation gala outside of the definition of the term gift for purposes of reporting. Now, as it pertains to the commissioner on whose behalf Mr. Horowitz has requested this opinion, the scenario Mr. Horowitz has described implicates the exception found in section 112.312, subsection 12B1, Florida statutes. This provision excludes the following from the definition of the term gift for purposes of disclosure: salary, benefits, services, fees, commissions, gifts, or expenses associated primarily with the donee's employment, business, or service as an officer or director of a corporation or organization. Now, first, it's important to note that the exemption in the statute does not require that the donor of the gift is the corporation or organization itself, but merely that the gifts be associated primarily with the public officer's position with the corporation or organization. To give an example of a recent application of this exemption, in CEO 14-26, a local chamber of commerce offered to designate a city councilman's private insurance agency as an endorsed vendor and promote his business to other chamber members. There, the commission found that the exemption found in section 112.312 subsection 12B1 would be applicable even though the gift was not given to him by his own insurance agency, and he could accept the designation as long as he had not solicited or accepted the Chamber of Commerce endorsement in circumstances that would render his acceptance prohibited by section 112.313 subsection 2 or section 112.313 subsection 4 Florida statutes. Now, turning back to the present inquiry, based on the facts Mr. Horowitz has presented, the commissioner, by virtue of being a voting delegate, is on the board of directors on the Broward League of Cities. As such, it must be determined whether the gift of the tickets to the installation gala is associated primarily with his service on the board, as that is what the exemption in the statute speaks to. So we find that a gift is associated primarily with a person's position within a corporation or organization when it is provided in circumstances directly linked to his or her service to the corporation or organization. For purposes of the exemption in section 112.312 subsection 12B1, it is not enough that the gift's actual relation to the reporting individual's service to a business entity be nominal or secondary. Now here, the city is providing the commissioner tickets to an event hosted by the same entity on whose board of directors it appointed him to serve. Additionally, Mr. Horowitz has indicated that the installation gala is an inaugural ball where the members of the Broward League of Cities Board of Directors are formally sworn in for the year. As such, it appears that if the city gifts the gala tickets to the commissioner while he is serving as its designated representative on the Broward League of Cities Board of Directors, this would be a gift associated primarily with his service as a director of the Broward League of Cities. Therefore, the commissioner would not need to disclose his acceptance of the tickets pursuant to section 112.312 subsection 12B1. However, the other commissioners who are not on the board of directors on the Broward League of Cities would have to disclose those tickets. Now, although the statutory exemption takes the tickets out of the definition of the term gift for disclosure purposes, section 112.313 subsection 2 and section 112.313 subsection 4 are still applicable to the commissioner, as is addressed in CEO 14-26. As such, if there is any indication that the tickets are being given to influence his official actions as a city commissioner, he is prohibited from soliciting or accepting them, as is in line with those two statutes. So that is all I have for this. Thank you for your consideration of this opinion, and I'm happy to answer any questions.
Does anybody have any questions on this one?
The first question, I'm troubled by that. The second question, I'm not troubled by your concluding that he does not have to report the tickets because he's receiving them in his capacity as a representative for the Broward League of Cities. I'm troubled by the first question where you're saying that he's purchasing the tickets with funds from the city in his capacity as in working for the city, and that when he purchases those tickets, that doesn't have to be reported because he's executing his duties. But when he receives the tickets, he has to report that? Is that?
Through the chair, yes. So we're not saying that the purchase has to be reported. It's the fact that he has purchased them in his official capacity as a city commissioner, but then is using them in his private capacity that turns those tickets into a gift that he is receiving from the city. So that is when they need to be reported, is when he actually accepts them in his private capacity. For example, he could make a sponsorship to the charitable organization by purchasing a package that includes tickets to events as a city commissioner, but then give those tickets to someone else to use, and then it would be that person who would have to make the gift disclosure. But because he's, in this scenario, taking them himself in his private capacity, that's why it becomes a gift he has to disclose.
Yeah, it seems to me that we're almost splitting hairs on the side of requiring reporting where he's just executing his duties as commissioner. I mean, if the commission did not give him the funds and did not direct him to use the funds towards charities, then this would not be an issue. But those are part of his duties as commissioner, to receive these funds and to purchase these tickets. And part of that process is to then receive these tickets. So that's the splitting of the hairs that I don't like with this. And it seems that we're creating additional paperwork requirements for him to report receipt of these tickets when he's just doing his job as commissioner. So it's not like he's using his own personal or receiving funds from a third party, he's using his own fund. Using his own funds. He's using funds that are in execution of his duties as commissioner. So I don't like the application, and I think it's too broad of an application in the first question.
I'm concerned because the accountability of the elected official and whether or not they have to declare or not declare, because elected officials can go get tickets, say to a baseball game or whatever is being offered, and that tickets are available through the county or the city, and then they would not have to report them, but they've been actually given to another private or 501c company, and they would never have to report that. Is that what you're saying?
Through the chair, no, that's not what we're saying. What we're saying here is the reason he has a gift to report in the first place is because he has received something of value personally for which he provided no consideration. That is the definition of the term gift, and that is why he does have to report his acceptance of the tickets.
Your opinion is they still have to report. It still has to be reported. They can't just escape the report clause.
Correct.
Are the tickets the gift or are the discretionary funds the gift?
It's, through the chair, it's the tickets that are the gift, because that is what he has received of value to him. The discretionary funds are not a gift to him. That's something that the city gives to every city commissioner, and they have to use it for a public purpose. But in this situation, in furtherance of him using those discretionary funds for a public purpose, which is, obviously contributing to a charity that does good things in the community. As a result of that, however, he has also, in his private capacity, received something of value in this situation. Again, as I was mentioning earlier when I was answering Commissioner Bain's question, there could be a scenario where he makes this sponsorship, he gets the tickets, but then he gives them to someone else. Maybe he wants to give the tickets to one of his friends and he doesn't want to keep them for himself. In that scenario, he would have nothing to report because he's accepted nothing of value to himself. It's the fact that he ultimately is keeping these tickets for his personal use. That's what makes it a gift to him. It's not the use of his funds.
So in his public capacity, he's receiving the funds. In his public capacity, he's buying the tickets, but somehow in his private capacity, he's receiving the tickets?
Through the
That's what I don't understand, because it seems to me that he's still receiving the tickets in his public capacity because he's completing the execution of a transaction that he was required to take as a commissioner.
Through the chair, so I understand that it can be confusing, and when we were hashing this out when it was being drafted, this was a discussion we spent a lot of time having. How this usually happens is the city receives tickets and then it individually disperses them to city commissioners and then they can go to an event. But in this situation, that idea is all sort of happening at the same time. Again, because he has expended public funds on this charitable organization, and he gets tickets in return for that, he's receiving those in his public capacity. But the fact that he is ultimately keeping them for himself and using them, that turns into private capacity, his attendance at whatever the event is.
How do we know that he's not attending as a commissioner?
Through the chair, honestly, that's a good question, and I don't know if Steve would have any thoughts, but.
Yeah, a couple things. First of all, I want to make sure we all understand mechanically what's happening here, because we keep associating the expenditure of the money with him and the giving of the discretionary funds to him. I think it's easier to understand that these funds are being delegated as he becomes the purchasing officer of these funds through his office. His office has delegated the funds to spend, and his office makes the expenditure, right? This is a city function that's happening, and he is charged with executing it. So his office is making a purchase, right? He himself has not made a purchase, and these are not his funds. The city goes and makes a purchase, the city then receives tickets. The city is a bunch of people, right? The tickets come in, he physically receives the tickets because he's the purchasing officer of them. In his official capacity, he's received tickets on behalf of the city. The city has charged him with the ability to apparently through this request, the city has apparently charged him with the ability to dispense these tickets to someone who has some city official. If he keeps them for himself, he attends in his personal capacity because what we're talking about here is a gala and a dinner, right? And that happens in he doesn't have a regulatory function eating dinners, right? So that's a personal capacity thing that's happening here. It's not as if, to give a different example, it is not as if somebody, like a county employee who has a regulatory function at a race, they have to go and attend to the race, and because they have a regulatory function there, they're monitoring the race as where they're doing their job. This is attending a dinner, eating a dinner, glad-handing people. And that's a personal capacity function. And that's not new in this opinion. That's not even new in 1917, the opinion that this relies on. We've been saying that for decades, that you don't accept dinners and galas and dancing affairs and entertainment and music and song. You don't accept those in your official capacity. Those aren't official capacity things. Everybody wants to see the mayor at these things sometimes, right? But when the mayor goes and attends these things, he eats dinner in his personal capacity. We've done prosecutions, numbers of them. We've gotten plenty of stips where the respondents themselves agree to the idea that this is a personal capacity gift that they've received. So that's not new, and I want to make sure that that's clear. This is not an official capacity conduct that's happening. When he converts the tickets to his own use and then uses them.
All right, so the opinion will direct him then to file the required forms to disclose the receipt of the gift.
He would disclose, he would disclose a Form 9, which is the gift disclosure form. It's disclosed on a quarterly basis. He would list the city as the donor, which is not new in this opinion either. That was covered pretty well in 1917, the opinion that this cites to. He would list the city as the donor. He would disclose the value of the tickets as the value of the gift. And if he's received multiple tickets for, let's say, if he's received multiple tickets, then he would disclose whatever the total is.
Did you have another question?
I do, because some of these ticket disclosures get missed. The issue that I wanted you to address too is when they receive the tickets in their capacity, they take the tickets, and they've now decided that they're going to give it to a 501c3 for them to fundraise on. Or, after consideration, they decide that they're going to go, but you have no way of knowing if they attended unless their photo was on Facebook. So, you've got an inadequate reporting in certain circumstances. So I just want to know what the law is for that scenario, and if this applies to what the request is today.
Through the chair, so a gift is, again, the key word is which is accepted. That's when you have to report. So if you get something but then you give it to someone else, then you don't have anything to disclose because you did not accept, again, anything of value for which you personally provided no consideration. So in the example that I think you were trying to ask about, where he gets these tickets but then he gives them away to someone else, for example, maybe he gives them to charity, there's nothing for him to disclose because he hasn't actually accepted a gift himself.
At what point, if he decides or she decides to keep the tickets and go, how do we know that that occurred?
Through the chair, again, the burden is not on us to know when they went. The burden is on the reporting individual to disclose their acceptance of something. So if someone accepts tickets to an event and then they go to the event and then, assuming their value exceeds $100 and then they don't file a Form 9,
if someone filed a complaint about that, we would certainly investigate it. But it's on them to make the disclosure when they accept.
Steve?
I don't mean to interrupt, and Amelia's explanation is really good, and this is a really well-written opinion that she's done here. To put a finer point on it, to answer your question, Form 9, like all of our disclosures, they're self-reporting driven, right? So it's the public officer or the public employee has a duty implicit in the code of ethics that they've got to file their own form, regardless of whether or not they might get caught, right? And the only way to do the enforcement, like Amelia said, is if we get a complaint from the public. That complaint, of course, needs to be supported by personal knowledge or information other than hearsay. But that's the only enforcement mechanism we have when they do not do the proper self-reporting. And you see those complaints in executive session all the time. The other thing that I want to make clear, which is important, is, Amelia said that if he decides not to use the tickets but decides to give them to someone else, I want to be clear what we're talking about in that instance is not if his office receives the tickets and the office decides that somebody else should go, somebody else in the city, let's say, then he's not personally received something, right? I want to contrast that with what I thought maybe you might have been asking about, which is what happens if he takes the gifts and then he gives them to his second uncle, right? Or some other person in his personal life. He's received tickets now and he's taken dominion of those. And now he's made a personal decision. I'm going to give these to a friend or a relative or to somebody else. In that instance, he has received something of value, right? And he gets the credit of giving it to a good friend. But he's got a gift to disclose in that instance. Just the same way if someone gave me a gift and then I re-gifted it, I received a gift. I received a value, something free that I didn't pay greater or equal consideration for. And I would have to do the self-reporting on the Form 9.
Again, that, leaves it up to the discretion of the commissioner that may have received it, and giving it away to a friend or relative, we would never know that happened unless someone had proof that had occurred and they complained. So that there alone, I think, is not what the law intended. But thanks for the explanation.
Yeah, thank you both for answering the questions. I think you did a great job. Thank you.
Are there any other questions, or is there a motion?
Madam Chair, I want to go back to where they are an officer of, say, in this case, the league. The opinion holds that in that case, they are doing kind of the duty of that office, or the city office, and serving the city at that. So it would not be reportable if they're like the designated officer from the city for the league. But then I think there was something about the backup designee not meeting that. Can you just touch on that a little bit more?
Yeah, so through the chair, that exception, to be perfectly clear, that goes to people who receive something of value that is primarily associated with their service on the board of directors or as an employee or with a private business. That's not, the exception isn't going towards something they receive by virtue of being a city commissioner. That's, something they receive by virtue of an outside non-public employment or sitting on the board of. So to make that clear, but then also regarding the alternates, we, in this opinion, we said that they would still have to disclose receiving the tickets and they would not benefit from this exception because the alternates are not actually on the board of directors. With exceptions like this, we have to narrowly construe them, and the statute only speaks to service on a board, not service as an alternate to a board member. So that is why the alternates do not get to benefit from that exemption, but the one who is actually on the board of directors does.
Commissioner, only because it looks like you may be wanting for a little bit more information. There's a definition of gift in the statute. You've heard it a couple times now, that for which greater or equal consideration has not been given within 90 days. The statute's actually quite generous in this area because it then gives you a list of, subparagraph A is a list of all the things that would be included in that definition. And then there's subparagraph B, a list of things that are not included. And what Amelia is referencing is there is an exception in that list of things that are not included in a gift. And that would be which one is it? B1. Yes, so the list of it is, and I'll just read it to you because it's short. Salary, benefits, services, fees, commissions, gifts, or expenses associated primarily with the donee's employment, business, or service as an officer or director of a corporation or organization. So if they're getting a gift and it's primarily associated with that service, then the statute has said that's not going to be a gift, and you don't apply the gift law. You don't do the self-reporting for that type of gift because it's not even a gift in the first place. The draft is saying it's primarily associated with their service as an officer of this organization, because the organization is the one hosting the dinner. The city who put him on that board is the one giving him the gift. It's very closely tied, in fact, to his service on that board, right? The other people, they're alternates, right? They're not even on the board. And so, strictly speaking, as Amelia said, they don't get the benefit of the exemption because they're not officers yet.
Is there a motion? Motion to adopt the draft opinion? Any modifications? Is there a second?
Second.
All in favor?
Aye.
All opposed? Okay, thank you. Appreciate it. Thanks, Steve. Okay. Let's do item 7, and then I agree, because I think item 8 might take a minute. But Hope Springs Eternal on this one. The next item for consideration is our 2026 meeting schedule.
I have one thing to say about this meeting schedule. It is exactly like the ones you've received in the past. We did tweak it in one way. We changed it in one way. We added a tentative virtual meeting, Zoom meeting in February in case we need to discuss any legislative items as a commission. So we wanted you to maybe agree to that, have it on your calendar, so we don't have to scramble during session to try to see if you all want to convene one. So that's the only difference in this from in the past, and let us know if you need us to make any adjustments in it. Otherwise, please accept it as read.
I think that's a great idea to add that. Does anybody have any questions or concerns about the proposed schedule? Is there a motion to adopt the schedule proposed?
Moved.
Is there a second?
Second.
All in favor?
Aye.
Okay, it is 10:21. Let's start back at, we've got, so we need a comfort break. 10:30 on the dot.
Oh, yeah.
At 10:30?
Oh,
recommendations. This says we have a memo in our materials.
It's in your
It's in our supplemental mail out, is the memo with recommendations to discuss. We're not limited to discussion of the items on that list. Members can have additional items to ask staff to add to this list or research to discuss at our next meeting. And ideally, we would take a final consideration and adoption of legislative recommendations today or at the September meeting, I guess with the caveat that we'll have the February remote meeting to tie up any loose ends as session gets underway. So before we begin, are there any members of the public here to speak on legislative recommendations? No? Okay. All right, Ms. Stillman, have at it.
Okay, in your supplemental materials, you were provided with a number of items regarding legislative recommendations. I'm going to run through them briefly with you today. What we have to do is decide what legislative recommendations you want to make as a priority and how you want those to be lobbied when the next session starts, which it starts in January. So that's why we're starting early. I would imagine today will be the beginning of the discussion. Hopefully we can get these finalized by September, because October they start having committee meetings. So the memo outlined items from last year as well as things throughout the year that you all have mentioned that perhaps we should discuss on a legislative discussion, as well as some items staff has identified. So I'll start with the things that we had on our list last year that did not pass. One of those items was related to gift acceptance and disclosure. And last year, we noted that the definition of relative did not include foster parents and foster children. And we recognize that not all children are adopted by their foster parents, although there is that familial relationship that they continue to have into adulthood. And the commission recommended that the legislature consider amending the definition of relative to include foster parents. We did not have a bill on that last year, but that was a solid recommendation from the commission that you could choose to put on the list again for this year. Another recommendation that was on the list last year related to the whistleblower-like protections for ethics complainants, where the threat of adverse employment action or personnel actions in retaliation for somebody filing a complaint would discourage the filing of valid ethics complaints. And so the commission, sought a legislative solution for that. This was something that's been on the commission's recommendation list on and off for a few years, and then with the implementation of the requirement for personal knowledge and information other than hearsay, last year the commission felt like that issue was ripe for consideration by the legislature. We did have Representative Benneroach in the House who sponsored this bill, and Senator Gates in the Senate who also sponsored the bill. With good language in there. They were not exact. I don't know which one's going to get. Is this better? Okay, sorry about that. We did have two bills on the whistleblower last year in the legislature that were filed. They did not get heard in any committee. However, you might want to put it back on the list for this next year if it is still your will. Often ideas that go before the legislature don't pass the first time around, and we still have that personal knowledge and information other than hearsay requirement in the law. Having a whistleblower type protection might allow the persons who have personal knowledge or information other than hearsay to file valid complaints on possible corruption. There are other ideas within this list. One relates to the personal knowledge or information other than hearsay. This is an issue that has affected the commission's cases over the course of the last year. So staff took a stab at maybe providing an exemption for documents like police reports or investigations, audits, inspector general reports that are filed that would seemingly be legitimate sources of information, but that sometimes contain hearsay, double hearsay or triple hearsay within them, so we can't always rely upon them when determining whether or not a complaint is based on personal knowledge or information other than hearsay. I'll note for the benefit of our new members, and a reminder to our existing members, the determination as to whether or not a complaint is based on personal knowledge or information other than hearsay, we undertake that during the sufficiency analysis of complaints. So when you see your draft recommendations of legal insufficiency that get taken up in a closed executive session, those analyses lay out whether or not the complainant had personal knowledge and how we know that that person had personal knowledge, because they have to state that in the complaint, or if the information that they've provided as a part of their complaint would constitute information other than hearsay. And so complaints often contain more than one allegation. Some complaints will have one allegation, some could have 10 allegations. We take each complaint allegation by allegation to determine whether or not that standard is met. So a complaint could be sufficient to be investigated on one allegation, but could have other allegations that fail on the personal knowledge or information other than hearsay. So it's not one thing or the other. It's usually different things. Now, when it comes to items being dismissed for legal insufficiency, and you probably noticed this in your meeting materials, there are a lot of times there are complaints that don't have personal knowledge or information other than hearsay, but they also would have been otherwise legally insufficient even if they did have personal knowledge. So we do see that impact cases in a variety of ways. Certainly, we've had to come back and deal with cases that were investigated prior to the law being implemented, and have had to parse out different allegations and drop those because they didn't meet that standard. This was staff's idea as a way to improve the process such that we could rely on these types of documents in making that determination. So I'm sure you'll have a lot of discussion on personal knowledge and information other than hearsay, Madam Chair.
Sure.
I heard your listing of that needed to be looked at, but what about media's first-hand interviews? Is that going to be considered?
Through the chair, that was not included in the draft idea that we put in front of you. Whether or not that's something you all would want to include in your recommendation would be a decision of the commission. Whether media accounts of things would be included.
I'm not speaking of just in general media, but first-hand interviews with.
That can all be a part of your discussion as to whether or not you want to make a recommendation relative to this type of thing, and if so, what that recommendation would be. We just provided this as a starting point, and I think Madam Chair, Steve has a...
Commissioner, a firsthand interview with somebody's own statements, depending upon what it was, it might be considered to be an admission, in which case there is a hearsay exception for that, so we may not need some sort of legislative intervention on that line. These other things, though, they're a little bit different. They're sometimes interpreted to be double or triple hearsay, and it becomes a lot more difficult for us to be able to rely on those for our complaints.
So you think that is covered under today's rules?
It's hypothetical, and mileage is going to vary on specific facts. But there is already a hearsay exception for admissions, and we do, under our rule interpreting this statute, under our rule, we do account for the hearsay exceptions to bring things in.
Do we want to? Yeah, why don't we do that? Because everyone's gonna have immediate reaction. So before we go on, let's look back at the recommendations from last year. Does anybody feel like we need to take off either one of the recommendations from last year? Or should we pursue those again? Mr. Bush?
Well, it'd be my thinking, last year's legislation, I think that we need to look at the two that we recommended, and also look at why you don't think that, we were able to move those two pieces of legislation, and I think we need to be more specific if we have to just target one of the, projects, you know, instead of trying to get both of them. You said one did not even get agenda, right?
The whistleblower legislation was assigned to committee but did not get heard in its first
And
committee.
why do you
so-
think that, was it the lack of participation from the commissioners? You didn't have a lobbying team from this group to go and meet with the speaker, talk to the governor, and with those who are, who's pushed that, who navigate that process?
You know, I wouldn't begin to dissect, you've been in the legislature, you know, through the chair. The legislature moves as it moves sometimes, and I'm usually the last person to know why that is, but we certainly had strong sponsors for those bills, and we did have, you know, members, you know, reaching out, doing what they could. Each year, you know, is sort of a different set of priorities and things that move through. And, you know, if it's a worthy idea, then we can maybe be a little more aggressive with it. If you all feel very strongly about it, we have a number of members who I think have great contacts in the legislature who can help to push that through if we should be able to find sponsors and get behind it, maybe get behind it early and socialize it earlier to maybe a little bit more of a grassroots approach.
I would also fall on the sword a little bit because 2 sessions ago was very active, and there were a lot of changes, and so I think there was a conscious decision. My thought, and like I know I thought there was a bit of a conscious decision to just not be too heavy-handed last session, to keep the peace. That said, you know, like Carrie said, if you know, the will of the body is to be more aggressive about our legislative recommendations this year, then I think that's something we could do. I do feel like it was a little bit of a conscious effort last year, which is probably my fault as the person who nominated to have to go talk to people.
And I do feel that this year might be a bit different. Senator Gates used to serve on this board. He would have a good understanding of what we're asking for, what happened, and why the whistleblower language was at the very last minute when it was passed, and a lot of people didn't understand what they were passing. It was passed on the floor at the last minute. So I think we've got a chance to go back and explain the impact of what it has on the ethics board. So I think we can lobby better this year and early. Because if you get too late into the committees, you're not going to get on the committee agenda.
Through the chair, Senator Gates was chair of Ethics and Elections in the Senate last year, and he did invite me and Steve and Commissioner Deskovich stood in for the chair at that time, and we did give them an update on the commission operations, and I specifically spoke to the personal knowledge or information other than hearsay. And so you're right, he is a former member. He did sponsor that whistleblower legislation, and I do not know if he intends to sponsor it again next year if you all recommend it. We will certainly work with any member of the legislature who would be willing to sponsor it, but I'm hopeful that Commissioner Gates might, Senator Gates would consider to, you know, sponsorship of that. But we have not had specific discussions on that.
So it would be my recommendation that we only recommend 2, and we put specificity on one that we can all get behind and really try to push aggressively. That would be my recommendation.
In that case, should we just, let's
Yeah,
go,
move to
keep
the
going
other
through the
ideas.
list then and talking through some of these proposals. So we were on personal knowledge or information other than hearsay.
Okay.
Commissioner Stuber had a great question about that. Is there anybody else who wants to discuss this proposed legislation on this personal knowledge or hearsay issue?
I have some strong concerns about pushing for this proposed legislation. I think what was noted in some of the discussion of it is these public records are filled oftentimes with double hearsay, triple hearsay, the reliability of the public record, although it's authentic, you can use it in court, sometimes for judicial notice, for authenticity of the document, with the movement towards personal knowledge. My concern is by expanding to the public record, it would undercut the legislature's decision to make the personal knowledge requirement. Oftentimes, just reviewing materials, people can put stuff in the public record where an email can be sent, and if it's not done by the respondent, it's done by a complainant or someone else, it can create an issue there that wasn't there. And so just relying on the public record alone or using it as a basis for initiating a prosecution or an investigation concerns me that it could significantly undercut the movement that was made in the 2024 session.
Steve, did you want to be heard?
This language that's in here, that came from us, or from me. What we were hoping, or what I was hoping that we might be able to push for is not just any old public record, but certainly ones that are created as a function of law by the agency itself. For example, one of the most common types of public records that we get complaints based on are where the agency hires a law firm to go and do an investigation of its own officials. You know, those things are, that report that comes out, there's some inherent reliability to that. What we're not asking is that we prove the ultimate matter on that, right? To get started with an investigation on something where the agency has relied on it itself, you know, that the agency that commissioned that matter, they've relied on it themselves to dispose of the matter. There's some inherent reliability, or at least we would think maybe enough to get started investigating something ourselves if someone brought it to us.
I think my concern with it would be, I think it can be used as a basis if the investigation is open to identify potential witnesses, but with the personal knowledge requirement now, I believe that it creates a potential, even as someone who's done those investigations in a lawyer capacity, you still have a gloss on it from that lawyer of how they interviewed that witness, how they interviewed the individuals, who was willing to come forthcoming on certain topics. And so I think, particularly in light of the recent legislative change, really focusing on that personal knowledge and limiting it to that and not expanding it at this time.
So, assuming that there's some, like, critical mass of audits and investigatory reports or police reports that are being culled out, and there's a feeling that they shouldn't be, instead of, this could be a terrible idea, but instead of sort of making a carve out to this personal knowledge and hearsay mandate, would an alternative way to maybe capture a subset of issues that we think might be inherently reliable to propose expanding, like, the type of referring agencies? Or, I know that we can't take complaints from municipalities, right? Like, we can only take them from individuals. You know, that might open something up that doesn't sacrifice the mandate that, you know, we got from the legislature last year. Tell me why that's a terrible idea.
It's not. It's very creative. It's a very creative idea, and it addresses the scope of what we're looking at in a different way, right? It doesn't address the hearsay issue head-on, but it allows agencies, more agencies potentially, to put an issue that if the agency feels like it's something that we should be looking at, sure. I mean, that's something that's a policy discussion that you all could have, but that's not, that doesn't jump out at me as, not worth discussing. It's certainly worth discussing. What we're trying to address here, of course, is, the underlying irony that, ultimately these matters get proved in an administrative hearing at DOA, right? And hearsay is admissible in DOA. So in order to prove the ultimate fact, we can use hearsay, but it gets started on a thing where there's a much lower standard, just getting started on an investigation, we can't. And so, it's not that these things will never get used as part of the evidence of the case, and not only will they get used, they might get used to prove the matter, but we can't use them to base our initial foray or a decision to look at the matter. And there's a bit of an irony there. So what we're trying to do is we're trying to look at some of these documents that are maybe, a newspaper report is obviously straight out, and nobody's asking for that sort of thing, right? But there are things, there's a scale, and what we're trying to do is apparently the public thinks that these things are worth us looking at because they're including them in the complaints, right? And so in order to address the apparent public perception that we should be doing that.
What, do we have, maybe you have the statistics, but what was the effect of this personal information rather than hearsay change on the number of complaints? Do you know offhand?
Through the chair, it doesn't affect really the number of complaints filed. It affects the things that get through the gate. We looked back at the ones so far in 2025 and a good number of the ones in 2024. It was roughly from what we could tell, about 20 different allegations that failed as a result of personal knowledge or information other than hearsay.
And from a percentage, is it 10, 20, 30, 40?
I would say it's a small percent. We didn't tally up how many allegations were in each complaint to compare how many were.
I think we accepted 250 last year, right?
So about 10%.
Somewhere around there. But, there's a varying number of allegations and complaints. I think the important thing to remember sometimes isn't the volume of the number that get tossed, but perhaps the nature of the allegation the person was attempting to make. They're basing it on an IG report or an auditor report, and it appears to be, a solid allegation, and we have to let it go. So to me, it's less about the volume and more about the quality or the nature of the complaint and allegation and the information that's provided to us and whether or not we're able to order an investigation.
Can you talk a little bit more about how DOA hearings are allowed to have hearsay?
Yeah, sure. Under Chapter 120, so Chapter 120 is the Administrative Procedure Act. The Administrative Procedure Act is set up to make it easy for lay people to access government and to prove their cases or not prove their cases, right? And so one of the things that happens in an administrative hearing, as some of you who have administrative practices know, hearsay is admissible in an administrative hearing. And so it can be used to prove the ultimate merits of the case. So what the law did, what Senate Bill 7014 did, is it changed how we invoke our investigatory jurisdiction to create a report that may or may not ultimately end up in an administrative hearing. But if that matter does end up in an administrative hearing, circumstantial evidence is allowed, hearsay is admissible. It just goes to the fact that it's hearsay just goes to the weight that the ALJ will give to it. My understanding is we use hearsay to prove some cases sometimes.
And then it's corroborated with other evidence. It is accepted and can be corroborated. And as he stated,
Can't be the sole basis for a factual finding, but it
Right.
is admissible.
But it's admissible, and then, it can be talked about, and then what weight they give it is going to be affected by the circumstances of the case and what else is in the record.
I think my fellow commissioner makes a good point. And I'm new to this, so I'm still digesting. And I think we have a chance to chew on this a little bit more going into the next one, so this is initial. But I think the direct knowledge is important, and or rather, I think it's just easy to backdoor hearsay into what we're looking at if we're not. And I think that's where, we're not trying to do that, but some of we're basically asking if we can, to my understanding, broaden our sources a little bit, and we have to, some of those sources may have hearsay in them. We're then asking if, okay, did the processes that they went through, whether it's an IG or administrative hearing, did they do enough to maybe filter it out or comb it down to now use that as an input into us? Because our senator is very high of knowledge of it, direct knowledge. Our investigators directly talk, I think, to people involved. So I would like to think about this one a little bit more, but I see some possibilities of broadening past maybe where the law is, depending on where we go.
I agree, this one's something that we need to think long and hard about.
Absolutely. These are just, this list comes from things that have come up in discussions. We put it before you, and you all decide if you like what's there, if you don't, if you want to change it, or if you don't want to make that particular recommendation. You can take more time and look next year and decide.
And it might be that, like, on this particular issue, because I know it's come up in a lot of meetings, that we just need to continue collecting a little bit more data to support, because I think the percentage question that Commissioner Bing asked is probably if I was in charge of the world, that would be the first question that I asked, is like, what's the practical impact that this has had? Because it's only been a year, and it was a policy choice that was made by people entitled to make it, so.
We carry that policy choice out as written.
Every single day.
Every day, every day. So, moving on to the next one, we had at least one member who brought up this issue, and the commission maybe wanted to talk about a little bit concerning vexatious complainants when it comes to utilization of the commission's resource. The proposal would be such to enable the commission to have a process to handle those situations similar to maybe what a court might have. I don't, in terms of what we see, the realities of what we see in complaints getting filed, you do sometimes see a group of complaints filed by a single person who then might come back later and try to take another bite of the apple. So that does happen. I don't know if we'll start to see that more because of the raised requirements, because sometimes people might say, okay, I didn't have personal knowledge or information other than hearsay, I'm going to get some more information and I'm going to come back to you. We see this more in terms of complaints under technical review that we reject, that I send back on a technical basis per the rule that you don't even see. Those people get very upset at that and sometimes, take us to court over it. So this is kind of a new idea. It might be worthy of more discussion or more research, but it is something that you've mentioned, so I don't know if any of you have any particular.
I may have been the one that suggested it, and I think it's, we had a couple of instances where people just fly off and file complaints against, ethics complaints against every commissioner, ethics complaints against the executive director, and then bar complaints against you as well. And my suggestion is that we look at this. I don't think that we'll have any remedy to recover any kind of fine, but I do think that what we can do is create a bar to any complaint even being considered unless it's filed by a lawyer after there's been a pattern of vexatious complaints. I think that that's an administrative remedy that we could probably pass. I don't know that we need legislation for that, or if we could pass a rule for that, but that, my suggestion is that we do something to address that, because it creates a burden on the staff, and it creates a burden on the commission to have to address this type of pattern of behavior. And I think if we nip it in the bud, it'll save time and effort and allow us to focus on more meaningful things.
Commissioner, I think if it's possible, and Steve, you might be able to give us guidance on this, if it's by rulemaking or otherwise, of maybe using the model from the Middle District of Florida. U.S. District Court from the Middle District of Florida has a very detailed local rule and policy on vexatious litigation and vexatious litigants, and can provide a model rule for us to follow.
Through the chair, we've talked a little bit about this, whether or not we would need a, statutory authority to do it, or whether it could be done by rulemaking. Steve and Gray might have more to say about that.
So, I'm talking with Gray. Gray is our chief rulemaking attorney for the most part on these types of matters, but I think he and I are in agreement on this. If we're free to make rules and procedures about what our procedures are and how we process complaints, we're free to do that. If we're going to do something like restrict somebody's ability to file complaints with us, where it's kind of just an open forum to the public, for the most part, we are sending a message that we want complaints. That might be, as a policy matter, that might be better coming from the legislature, but if you want to do it by rulemaking, that's something that we could take a very close look at and formally get back to you on.
Rulemaking seems to be the more expedient course.
Oh, sure.
And then let's take that, if the rest of the commission agrees.
So the question being an analysis of whether or not it can be accomplished through rulemaking.
Keeping in mind our dependence on complaints and good complaints. So we'll research that some more for you and look at it from the lens of rulemaking. The next one on the list, it's listed on your memo as a first-time fine waiver. I like to refer to it as a one-time fine waiver. We've had one-time fine waivers in place for executive branch lobbyist compensation reports for decades, and they've worked well. That's where if somebody received a financial disclosure fine or for compensation reports for the executive branch, but if a financial disclosure filer were to receive a fine, they would have the ability to invoke a one-time automatic fine waiver, provided that they went ahead and filed their form. This would accomplish the transparency goals that are so important in the law and to this commission. It would also provide a little bit more efficiency, as it would cut down on those particular fines being appealed, and it will raise the notice and raise awareness to that filer that they've used that fine waiver. If they get fined again and they appeal it and come before this commission on an appeal, they're probably going to need to have a really, really, really good reason for not timely filing. So that is the suggestion with regard to, financial disclosure and fines. So maybe somebody wouldn't want to invoke it if they got a $25 fine, but if they had a $500 fine or a $200 fine. But they wouldn't be able to receive it without first filing their form.
Any questions on that proposal?
Sorry, I have to share the mic. Two questions. One, are you saying that they might almost like hold their waiver card as, oh, it's not worth using it on this one, save it for a better one, or would it be like the first time? So do we say first time or one time? Or?
That would be up to you. You all could say, all right, you can use it, the recommendation would be a first-time fine waiver.
The better implementation might be first-time automatic waiver, and this way there isn't any sort of holding it for a better opportunity. If we're trying to achieve notice, you did it once, we're telling you once is enough, as you saw from the last virtual meeting, the board's been struggling, or maybe discussing, the board has been discussing the matter of, do they have notice or not from being through this process before? Do they have notice every year that they're required to file? Because the filing note requirements sometimes change or whatever. And also, there's been this discussion about the administrative burden of doing these appeals, and most of these people, we do it once and then we never see them again because they're on message. So this would just kind of address all of that in one policy maneuver.
And we're talking, this isn't like us adopting a rule or internal, this is like, hey, for legislature, consider it, right?
Yes.
Okay, I think the only other thing in particular, this one, like the process changed significantly, right, with the online filing for this. We're in our second year of executing that right now, so I'm not sure how I feel about that one, but the process, you know, that may mean we're gonna get more of them. I think it's hopefully gonna mean that people get tracked more in the system. Yeah, at some point I would like to, I know that the governing bodies themselves have a person who is tagged with really kind of moving a lot of these, and I think that may be another area of focus that I would like to see, because especially when someone leaves an organization, that seems like almost all of the cases is they left and the notices are going to where they worked, and where they worked is like, they're not here anymore and that's where it's false. So I don't know if that's associated this or not, but that seems to be still the biggest gap in the system to me, especially if they're a personal email address. Now I know that should follow them when they leave, right? But we'll see how that works out.
Email addresses continue to be, you know, the difficult thing with regard to e-filing, having accurate email addresses, making sure everybody has email addresses. But yes, there is confusion when people leave office. If they leave after December 31st, they don't realize that they are still required to file that annual form, and they have that final form to file. With the e-filing system, if the coordinator puts the date in, they do get notified. But we have seen over the course of the years, I think, a number of disclosure fines where, like Steve said, they get fined once, they get the message, they either get the fine waived or they have to pay the fine. This would be something that has been in practice in a different area of law successfully before, that might be helpful in terms of the implementation of e-filing. But again, there's a lot of ideas, and you all have to decide what the most important priorities are going to be. Okay, the next three I would say are technical changes. The first is that an appeal in financial disclosure that is mailed to us, if it could be based on the postmark date rather than the date it is received, given how mail travels now. Somebody could mail something, and it could take it 2 weeks or more to get to us. They mailed it to be timely. You'd have a reasonable expectation that we would receive it, but then the appeal is untimely, and we have to deal with that issue. So that would be a technical change. Another technical change would be related to Form 6 filers, and just to clarify that individuals appointed to complete the remainder of the term of office for a Form 6 filer, they do have to complete the Form 6. Appointed to serve for somebody who has vacated office for one reason or other. That's the advice that we have been given because we think it's consistent with the intent, but it would just be asking for clarity on that. Another item for clarity relates to the ethics training, the 4 hours of ethics training. The legislature was very clear when they added special districts to, independent special districts to the training requirement, and indicated that if people appointed to fill an elected position were still required to take that training if they were appointed to fill an elected position on an independent special district. but the rest of that training law does not have the same language that would apply to, say, a city commissioner or a mayor or other elected position. So staff had the idea that that technical change would be helpful so that then that person would be required to take the training. Anything related to those technical items?
Well, thanks, Madam Chair. Executive Director, I think a lot of these seem like cleanup kind of type stuff. The post date in particular, I think is, I mean, that can be, so that can vary a lot by weeks. I think the federal government uses post date in many cases for establishing dates, so that makes sense to me, and seems like pretty good technical cleanup.
Okay. And the last one relates to public records exemptions. So it's not really related to ethics laws. Last year, the legislature afforded elected officials with public records exemption for information such as home addresses and phone numbers. Similar exemptions exist for similarly situated officials such as yourself. I looked over the confidentiality form that we use, and it appears that I think most, if not all, other Form 6 filers, and you all file Form 6, have a public records exemption for their mailing address and their phone numbers based on what was passed last year. There are exemptions for individuals who do investigations as well. As you'll note, many of the people who work with the commission are not happy to have to be talking to us. We have complainants who are can be very upset at things going on in their community, upset if the commission does not rule in terms of finding a violation. We have had, the commission has added additional security at its offices. During the day, we do receive a lot of phone calls from a lot of folks who are very animated, very passionate, and can often be very angry. We have received threats at times. We have had threatening situations with acts of intimidation or threats and attempts to interfere with the work of staff or the investigators, with complaints we're attempting to investigate, or complaints that have been returned on a technical basis. I'm not the only executive director who's received threats from individuals regarding technical returns. I know a previous director had an inmate who was getting ready to get out of prison who contacted the director, letting them know that they knew where they lived. So, so we put this before you for your consideration as to whether or not you wish to consider seeing if the legislature would consider providing some sort of records exemption for personal addresses and phone numbers, as well as some members of commission staff, if not all. You do have a higher standard of reporting than other people do, and every member of your staff files functions. For example, we do file a Form 1. But that includes our part-time college students who are clerks with us. They also file a Form 1, as well as any temporary employee that we have has to also file.
And if this is something that, staff feels is needed to feel safe, then I'm obviously supportive of it.
Yeah, Madam Chair, if I understand correctly, we're not saying remove the need for filing, but remove any potential personal identifying information that may have to do with safety primarily.
Just an exemption for.
A public records exemption for like
public
addresses.
records exemption for addresses.
So I guess now.
That's the list.
Yeah, we need to go, just figure out, so consensus seems to be that we need to think on all of these. And then I think the recommendation, which I think is a good one from Commissioner Bush, was that we be very strategic about which things we.
After listening to Executive Director, I think that we should also include the last one you just explained. We can include all of them, but I think that if we're gonna get any movement, we're gonna have to be engaged. And then we need to have a strategy as a complete commission when we go up the lobby. We can't just be one person. We need to have a collective group to target the individuals that can pretty much get our agenda, get our project agenda in the process. So I think it's gonna have to be a concerted effort. We're all gonna have to work together in order to make this happen. Because that legislative process is a difficult process. It took me 14 years to learn that. And I'm still learning. But I would think that we can consider more than just one or two items, but we need to have a collective strategy of lobbying that process when it starts. You said in September, right?
Well, I would imagine it can start at any time that, you all are ready to start it. I will note that, because this body is subject to the Sunshine Law, one of the additional challenges that we do face is that any sort of strategy that we want to make an approach of, we're going to talk about during a public meeting, and members of the commission, can't be together talking about this sort of thing. So we sort of have to, if we have folks involved, we'll have to.
You're talking about it now.
We'll have to, talk about it in meetings or call Zoom meetings and talk about it. Yes. Or, I can reach out to specific commissioners and say, this is going on. Can you reach out to your contacts and talk to them about, thus and so.
Understood.
So I imagine you want some of this brought back for the next meeting to discuss things in more details, or anything you want us to go ahead and take off the list, anything you want us to research more and come back with additional information?
Anyone?
Let's move, I think we should move forward. I think we have enough information. I think that we know what we have to do in order to get this process moving on our legislative agenda, and I think that we should move forward with it. That's just my opinion.
I mean, I think Ray and Steve are going to look at the, whether we have rulemaking authority on the vexatious complaints part, but other than that.
Yeah, my thought would be to come back with that. I think that there's probably a little bit more chewing to do, to use your term, on the public records, or not the public records, the personal knowledge piece. But I think if we all do our homework, we might be in a position to vote on a slate of recommendations in September without taking anything off the list right now. Does that sound like a reasonable?
Madam Chairman, I agree. I have strong reservations about the use of the public records for personal knowledge replacement. But I also agree with Commissioner Bush's point earlier of maybe at that next meeting, we prioritize maybe 3 topics and some of these that are cleanups, which one's the most demanding cleanup we need to get done. But I think the public records exemption, the whistleblower, I think whistleblower helps address some of our personal knowledge concerns. And we, as Commissioner Bush said, let's prioritize 2 or 3 and really double down the efforts on those 2 or 3.
Agree with that approach.
all of the ones discussed, I'm just really mostly going to focus on the personal knowledge part of it, so I'm going to be interested in how that may look in writing.
Okay.
Right, of the whistleblower.
I don't think we have anything to take a vote on at this time, is that correct? Okay. Okay. Well, thank you for that presentation. I think we're well positioned for next time. I guess moving on to the reports. Madam Executive Director, do you have another report?
Yes, I have another report, and I know you're so excited about it. I don't have anything to add to the executive director's report, but I do want to give you an update on financial disclosure and e-filing, because 'tis the season, and we're past the July 1st deadline. But I did want to let you know, oh, yes, it was, what a great group of people to work with to get that done. There were over 5,000 incoming calls to the commission during the month of June across all disciplines in the office, and that number, of course, will include any return calls. Many of those calls were disclosure calls. We kicked everything off with our notices going out May 20th. Close of business on that day, our compliance rate was about 15% or so. We sent out reminders on June 1st, again on the 16th, the 23rd, and the 30th, and notably, Monday was a test. Monday, June 30th was a test. We had our highest call volume of 791 calls coming into the commission that day. I think we all personally feel like we handled each and every one of those calls, but 402 of those calls were handled by our call center that day. There have been about 3,500 calls to the call center directly this season with a service level of 92%. The average talk time for our call center with filers is 9 minutes, including wraparound time. Calls are getting answered immediately. If they can't be answered within a few seconds, filers get what we call a queue callback. They can put in their number and be called back. Those callbacks, we've only had about 9 occasions where that has occurred, and they've gotten their call back within about a minute. Last year, we had about just shy of 97% overall compliance, which was a couple of percentage points lower than previous years. Our compliance numbers are running a little bit higher this year, and that makes me happy. We are currently at 88.63% compliance, about 88.7 of Form 1 and 86.8 of Form 6 filers. Last year at this time, we were under 87.5%. And last year at this time, we had a very high compliance number for Form 6 filers because it was a qualifying year. So that 87% number, I would say, was a bit inflated due to qualifying. So I feel really good about where we are in terms of compliance at this point. Beginning next week, August 1st, email reminder notices get sent weekly pursuant to statute. We are currently in the grace period until September 2nd. September 2nd at 11:59 p.m. is the last option to file a form without getting fined. Those $25 a day fines kick in after the 2nd. Our call center has begun its outgoing calls. With anybody we have a phone number for, the call center is making calls to them as a friendly, gentle nudge to go ahead and get filed. We are also preparing to send out our postcard mailings. Those have just been so successful in the past that even with the advent of e-filing, we want to go ahead and send those out. They tend to be getting people's attention. And we've seen since the implementation a noticeable decline in Form 6 assistance calls to our office. I think the Form 6 filers have been filing for maybe 3.5-ish years at this point, and I think the decline in calls is coming from a rise in familiarity with the system and clear understanding and, dare I say, the clarity of the system as it walks filers through. So we hope that over time, we'll see that same thing happen with Form 1 filers. You know, should the court affirm the law for municipally elected officials and mayors to file Form 6, we'll get a bump up in calls for Form 6 for sure with that, but it's nothing that we cannot handle. I do want to note importantly that as far as the development and implementation of the e-filing project, it is now transitioning into regular operation and maintenance. The team that was developed to build that system over the last few years, that's changing, and we're going into regular maintenance. We do still have a wish list of different improvements and things that we want to have done that they are working on. We do still have a team that if there's an issue that comes up, it can be solved. As I've mentioned at previous meetings over the years, the team at Olitz has worked incredibly hard on this. Your staff has worked incredibly hard on this, in particular, Kim Holmes, who is still working diligently back at the office this morning, our financial disclosure administrator. She is amazing, she and her team, and Lynn Blaze, who's here, of course, today. She and Kim, they did all of the testing, virtually all of the testing over the years for this system, in addition to their regular duties. So I'm grateful to Olitz, that staff AUG team, Tricia and Jess and the whole group of them just were fantastic. And we had great support from the House and Senate throughout that time. So I want to express our gratitude for that. And with that, the next time we meet, we'll be past the grace period, and I'll have some final numbers for you. But that completes my report.
Anyone have questions about e-filing report?
Madam Chair, just some comments. I didn't realize that outgoing calls were made from here, so that's a great proactive step. I'll just say, good job to the executive director and the staff. That's really impressive. Someone who has filed a Form 1 before and who has received the reminder card, it does work. So it's good to get. The technical system, especially like if you're doing it the second year, like the ability to kind of carry over data and just put in changes, that was really nice. In fact, it made it. For those, I know not everyone uses technology, and that may be some of that's where I think my concern goes to, is like, you have some people who are still paper and pen people and not computer people. I know that's what the help desk is for, and that's where we help, but it's a good system for those who are already online. So that's good to see. I did have one question. You mentioned many of the calls were disclosure calls. What's a disclosure call?
Financial disclosure.
Oh, related to the financial disclosure.
Yes, most of those calls that come in the month of June are people who have questions about Form 1, Form 6.
Thank you.
Is there a motion to adjourn?
Motion.
All in favor?
Aye.
All right.
Okay, it is 11:35. What time are we going to come back? Did you just say 12:30? You can come back at 12:30. 12 o'clock? 11:50.